We'll now call the final case on this morning's docket, 124469, State versus Crista Hinostroza.
Morning. Good morning, Your Honor. My name is Randall Hodgkinson. I'm here today on behalf of Crista Hinostroza, and I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, I would just of our mornings to remind you a little bit about this case. This is a case out of Lyon County where my client, Crista, was at her parents' house and trying to see her kids, but her parents, I guess, had a bad relationship apparently with her parents. They didn't want her there anymore, so the parents called the police, and the police came, and Crista said, well, then I guess I'll leave, but the police said, well, actually, it turns out you have a warrant. And so, as they're obligated to do, they placed Crista under arrest, even though she clearly doesn't want to go to jail, as most of us wouldn't. And she is transported to the jail. There's evidence in this case that she's asked at various points, do you have any drugs or guns on you? And she says, I do have some a needle on me, but she does not disclose anything about a gun. And then after she's at the jail, she's being booked and she is thoroughly searched then, as people are at jails, and find a gun in her bra. And so she has been charged and convicted and sentenced to 4 years for trafficking contraband in a correctional institution. In this case, that's the only charge that's at issue before this court today. I think the briefing in this case, I think sets out the issues pretty well, and you have the benefit of cases from other jurisdictions that have certainly landed on both sides of this issue. But the primary issue, as we framed it, at least for the first issue, is whether or not our client engaged in a voluntary act that could constitute trafficking in this case. I think we would all agree, that nobody thinks Crista voluntarily went to jail that day. She was put in handcuffs and put in a car and went and taken there.
Let me tell you what I'm wrestling with on this one. Grab that. I mean, besides, yeah, no, she doesn't want to go to jail, but she doesn't tell the officers about, you know. Why isn't that? Two things I'm worried about. One is, why isn't this a jury question? And the second one is, given our standard of review, light most favorable to the state, how do we overcome either of those two concerns that I've got?
So I'll start with the second one, which is, I mean, sufficiency issue. I agree. And so the standard of review is there any evidence in a light most favorable to the state? But we're arguing, and our first issue particularly, that there still has to be evidence of a voluntary act. Could it be a jury issue? I mean, it certainly is. I mean, it is a jury issue at some point. We didn't frame this, and there was no sort of instruction or argument made directly about that as far as getting a jury instruction. Maybe there could have been in this case. But putting that aside, Your Honor, there still has to be evidence of it. And so I don't think there's any evidence, as you kind of stated, that she went to jail voluntarily. The state's theory as to why there is a voluntary act, there's a voluntary act required for every crime in Kansas, is that sort of like you articulated, well, she could have said that she had a gun and therefore not taken it in. And as we put in the brief, I think there's two problems with that. And one is maybe distinguishing to some extent from some of the other cases from other jurisdictions, but Kansas statute that requires that you have a voluntary act under 215201, I think, you know, says it has to have a voluntary act, but now the state's transforming it not into a voluntary act, but an omission, that you failed to do something, and that's the voluntary act. And that's their argument. You failed to do this thing, and that's the voluntary act. But 215101B says an omission can only be sort of satisfy this voluntary act requirement if it's required by statute, and it's not. They could write a statute, I guess, that would say something like this, but that's not what's in there. The second problem with it, as recognized, especially by the Oregon court, but not analyzed at all by our Court of Appeals, is then the only way you can avoid criminal liability in this case and not do this is to confess. That, do you have drugs or a gun on you? And a gun from Crista is illegal. The only way for her to avoid this charge was to confess to another charge.
It's slightly different, though, I think, in that she didn't exercise her right to remain silent. She told a falsehood. She said, no, there's nothing else, but there was something else. Does that matter? I mean, what do we do with that?
So I don't think it matters in that, I mean, maybe she could be prosecuted for something else, some sort of obstruct, I'm not admitting that today. But is there something else that it could be? I don't know, maybe. But for the purposes of whether she engaged in a voluntary act by saying no, that's still not the, I mean, there's no showing that that caused her or in some way facilitated her introducing an item into the jail. That's not the thing. That's not what would make it a voluntary act. So I don't think it matters one way or the other. She could have been silent. She could have said no. Either one of those is just her engaging in that.
So you don't consider that a voluntary act that can be considered in a light most favorable to the state?
No, because it's not the introduction itself. It's some omission, or in that case, commission, I guess, right, that we would say. But it's still not the act, the voluntary act of introducing it. The state's idea is that she could have stopped this if she had admitted this, or she had not said no. But that's not the equivalent of a voluntary act. It might be some other voluntary act. I understand what you're saying, Your Honor, but I don't think it's the act here.
Does the attempt language matter at all in the statute in terms of her answer to the question Justice Wilson just mentioned? In other words, voluntary act for introduction, is there a distinction between that and a voluntary act for an attempt to introduce?
It has to do with, I think the attempt language could have to do with sort of intent. I mean, we have a second issue about mens rea in this case, but I don't think it has, I mean, the voluntary act, did Crista voluntarily act in introducing a gun into the jail? And did she, again, and I don't think any of us would say she voluntarily went to the jail. She would have been glad to not go to the jail that day. She told the officers, I don't want to go to jail. In fact, she kind of resisted the officers. And so there's no way you can sort of say that she was voluntarily choosing to do that today, or that her intent in any way, I mean, this is really our second issue, that her intent was to introduce a gun into the jail that day. That was never her intent, and there's no evidence of that. So those are, I mean, I think it's kind of answering a different question, but it's a separate question. You have to keep the mens rea and the actus reus questions separate. They're separate questions.
Well, can't they be connected? In other words, if there was strong evidence of intent, someone testified that, yeah, we concocted this scheme, smuggling scheme. At that point, the evidence of failing to reveal the gun might actually look more like a voluntary act in furtherance of an intent.
So in the hypothetical, as I understand, Your Honor, so I decided this is where we're going to get some stuff into the jail. Yeah. We'll make this scheme to get ourselves arrested,
right? Exactly.
And then go to the jail. I think I have a harder time arguing that that's not. I mean, that there's not, the voluntary act there is that person actually did want to go to jail.
Right. So it's not exclusively that failing to reveal the existence of a gun could never be a voluntary act. It's just simply that on this factual record, there's not sufficient evidence. See the distinction I'm drawing? And would you agree with it?
Not seeing that distinction yet, so I don't want to agree or disagree with it, Your Honor.
That's fair.
So, I mean, in the hypothetical that you're talking about, I mean, could there ever be a situation where, like, some facts or even some sort of like the denial or the failure to disclose, could that ever be? And I mean, the Conger case, the Court of Appeals, the unpublished case sort of below says, I mean, if there was some sort of meaningful opportunity to not do it, then you get closer there. And I don't know if that's sort of what you're talking about with the overlap, Your Honor. I still think they're separate analytically. I think they're separate. But in order for that to be true in a case like this, and this is the Oregon case does a nice job pointing this out, that you'd have to do something. I mean, the joke in our office about this was sort of like, well, maybe if you got to the jail and they said, okay, there's this box, we're all going to turn around. You put whatever you know can't go in the jail in that box, and we'll never know, you know. And if they didn't that, would that, but then they still went in, would that be a multi? I don't know. Or if the Oregon, you know, like the Oregon case, if you give them immunity, if the officers would promise them, and it was an enforceable promise that, look, we need to know if you have any guns or drugs before you come to jail. And we promise if you show them to us, you won't be prosecuted for those. Maybe, but that's not the reality. And I don't think that's what the state's advocating for in this case. The state's, on the other hand, advocating for a position that somebody like Crista can be caught in the vice of, you either confess to this crime or you're going to be maybe guilty of this other crime, a very serious severity level 5 crime. And that's in fact exactly where my client is sitting today, in prison, because she had to make that choice and that dilemma. Your Honor, I will submit the other issues on the brief because my time is running short.
I have a question on the notice. Is the knowledge that she might have had from her prior incarceration enough? Or does there have to be notice on that day as she's entering under the law, do you think?
Yeah, certainly our position is it's not enough, obviously, but it has to be under this court's rulings and as it's interpreted. Now, I still don't agree with some of this court's rulings about vagueness and delegation, but that being the case, this court has made it clear that in order for this statute to be constitutional, because it says any item can be contraband, but you're going to have to give then some notice that is substantially similar or something like that we would say to a statute, so we can give adequate notice and also protect against arbitrary enforcement. And so, Your Honor, our position is the fact that she knew about these rules, and she admitted she did understand the rules generally from past experiences, but that's not enough on a particular day, that in order for the statute to be constitutional, that you need to, now I don't know if you have to give it to them on that day, but you have to show that they had knowledge of in-force regulations or decisions by the jail that a particular thing was contraband on that day. I don't know if you have to give them that notice on that day, but you'd have to have evidence that the person had been given something so that they would know that it was contraband on that day.
So fairly contemporaneous, is that what you're suggesting? Or
Yes.
Other questions?
Thank you, Your Honor.
Hey, it pleases the court. I'm Brian Henderson. I'm an assistant county attorney in Lyon County, and I'm here on behalf of the appellee, the state. I would argue that the notice question is that the question of due process was overwhelmingly shown at court. First of all, by the fact that Ms. Hinostroza testified at court that she knew, at trial she testified, that she knew she was not allowed to have the gun in the jail. So she knew that, but not only did she know that, she was familiar with the policies because previously she was a part of the work release program that they'd had. This was in 2016, a situation where she would go work during the day and then come back to jail at night. And every single day she would walk past a series of 3 large signs that said specifically, and one of the issues argued was whether or not we have this individualized notice. Individualized notice said no weapons specifically. It said, I believe it said no illegal drugs, no weapons. It cited the possible no weapons, tobacco, or illegal drugs, and then cited what is now a defunct statute, but essentially just recodification of the same language. So she repeatedly, over a long period of time, had notice. She testified that she knew she was not allowed to have the gun. And then even when she was booked in on that day, she walked past the same signs that she'd walked past numerous times before that essentially re-urged the notice that she had.
Can you get to explain to me how this is a voluntary act on her part?
So,
What, and let me understand, she was arrested, handcuffed, correct?
yes, sir.
Put in a patrol car. She disclosed that she had a syringe. And she didn't have to do that. Maybe she did, which, well, I'm getting sidetracked here, but explain to me how any of this is voluntary on her part from the time of her confinement to when she's taken to the jail, put in the bucket, whatever area she's placed in. How is that voluntary?
I will concede to the court, as my learned counsel stated before, no one voluntarily goes to jail when they're being arrested on a warrant. That is something that you are done on the behest of someone else. So I don't believe that the
How is she trafficking in contraband when she has she has no choice in the matter?
So she did have a choice in the matter, Your Honor. Once she got to the jail, she had an opportunity to mitigate whether or not she went beyond the outside of the jail into the walls by virtue of that notice and an opportunity to disclose that she had the stuff. Now, the issue,
How does disclosure make a difference?
so once it's disclosed, then you basically have mitigated that mens rea, that intent to bring the stuff in, because I'm here involuntarily. But now I know that I have this on me. If I don't let them know that I've got bad stuff and I continue to go into the jail with the bad stuff, that then becomes a
I
voluntary
continue to
thing.
go in. She doesn't have a choice. She's being escorted. She has absolutely, she has no control over what happens to her at that point.
And the
In
syringe,
terms
sir,
of
is a
the
perfect.
physical, go ahead.
The syringe is a perfect example of how she did have control, because she told them that she had a syringe in her bra, and then they had the opportunity to remove that. Now, as far as a voluntary act, something that she actually did is when they went to remove the syringe, she got confrontational. She wanted to be the one to remove it because she knew there was a gun in there. So she then fights them and has to be restrained while they go to remove the syringe from her that she ultimately would not have been charged with because she had disclosed it. That's when they discovered the firearm, a very dangerous situation to law enforcement at that point. So the fact that she did not disclose that she had a firearm put her in the position where she could have continued on through beyond booking, potentially with that on her person. Now, she was a convicted felon. She was already committing the crime of a felon in possession of a firearm. And yes, asking her that question put her in this, I believe they called it a trilemma of whether to remain silent or whether to lie or whether to admit that you've committed that crime. But by not admitting to that previous crime, she now has elected, she's made a conscious decision to commit a secondary crime of bringing that contraband into the jail, something that she could have mitigated. Now, with regards to her right to remain silent, there are remedies to that right to remain silent. Had someone asked her and she admitted, and it had been an improper question as to whether or not you have a gun, and she admits that she has a gun, that could have potentially been suppressed. It could have been inadmissible. There are other constitutional things.
Or
that
she could have been charged,
She could have potentially been charged, but I don't know.
likely
that-
been charged. I mean, it's a crime.
It is a crime. And
So she has
ultimately-
two choices. I'm either going to get charged with, introduction of trafficking contraband or felon in possession. I mean, you're putting her in an impossible choice.
But it's not an impossible choice, Your Honor, because she knew going in that she had the gun. That gun, she knew
But
that she was going
is
to be searched.
being involuntarily taken into the jail. And you have this statute that other states don't have this statute, but 215201, I don't see how you can reconcile, when you talk about a person who omits to perform an act does not commit a crime unless the law provides that the omission is an offense. I really don't understand your position here.
And I don't believe that she's in trouble for any omission. She could have mitigated it by telling, but her omission's not what got her in trouble. Having the gun, making the conscious decision to have the gun and to continue on when she could have not continued on.
But I don't
is
get
where
that-
she is.
To not continue on, She had no choice but to continue.
She had no choice but to continue on, Your Honor, but she did have the choice to continue on with the firearm in her possession.
Right. And the only other choice to that would be to admit to committing a crime.
What I would say to that crime, though, Judge, is she knew at that point she was going to be searched, that that gun was inevitably going to be discovered. And she knew the same thing of the syringe. She did
Well,
not want them to know.
Doesn't that, don't the facts of the case completely undercut your argument? In other words, the fact that she disclosed the existence of the syringe, in fact, did not stop it from going into the jail. The syringe and the gun followed the exact same path.
Actually, no, when she was searched so they could remove the syringe so she would not then be booked in with the syringe. Because that's what they thought she had. Now, she made the decision not to tell them about both of the items
Well,
at the peril.
just help me with the facts. Am I wrong in understanding that the syringe and the gun were found simultaneously?
They were found simultaneously.
So they did, in other words, there's the only difference between the syringe and the gun is what she said to the officers. And it seems to me like under your theory, you could have prosecuted her for both.
But by disclosing that syringe, and there's a line when you go into the
That's my
jail.
point. She disclosed it and it didn't matter. It didn't stop the syringe from going into the jail.
She wasn't charged for contrabanding for bringing that syringe in.
Why
She was
not?
charged with the gun because she did not, it did not go past the booking, past
Well,
the
but
site.
neither did the gun.
The gun didn't because we found it, not because she.
So if neither one of them were taken past the booking, then how does it even qualify in the statute?
So from a public policy standpoint, I would argue that she told law enforcement, hypothetically, if someone were to tell them about a syringe and they know that there's a syringe and they're not telling them about a gun, and then she's not letting them search, she's fighting so they can't search her because she knows she has a gun, that puts everyone at peril. We have certain safety concerns and reasons that we have to know that these people have these things on them when they go in. She was actively trying to prevent them from knowing that she had that gun. While she admitted that there was a syringe, she was going to arguably try to get.
Then
to that
charge
gun
her with the
first.
interference. But if she didn't go in, if she didn't traffic, if you didn't charge her with the syringe, why would you charge her with the gun?
Because of that disclosure, Your Honor.
So it was all based on what she did and didn't say?
At this, if there was any other way she could have mitigated not bringing it in, but that would have been her
What is,
opportunity.
where in the
Yes.
statute does it talk about mitigation? I mean, how is that an element?
The element is simply bringing it in with her, Judge, and so I'm saying she could have not committed that crime, and part of not committing that crime is telling law enforcement, particularly when they asked her, do you have a gun you're going to bring in? Do you have a weapon? Is there anything that's going to poke me? That is the time when she's in the police car for her to say, look, I've got a gun on me. I don't want to bring in the jail because I know it's against the rules.
Well, just factually, were the items, I mean, there's this line, right? That
Yes, sir.
you can't bring it past. Did the items get past the line or not?
I don't believe they did.
So was the
That-
state's theory under the statute that this was an attempt to introduce?
I think that's a fair assertion.
Well, was that
What
what was
the-
argued?
What was the conviction for?
And the statute and help, as you're answering that, could you also, I think, because I think it's related to this, the statute talks about introducing any item upon the grounds of any correctional institution.
It does, and there have been cases that have dealt with, I think some of the cases cited had dealt with cars in the parking lot and whether or not a reasonable, otherwise innocent citizen could be on notice that an item of contraband in their vehicle is something that they could be at risk of being in trouble for. Being in my car in my parking lot, and as in Conger, it's the same kind of otherwise innocent type activity on the outside that would be contraband on the inside. Conger dealt with a pill, a prescription medication that was prescribed to that individual. Those types of things are things that are brought on, but they would be unconstitutionally applied because of the notice situations that we've talked about. But here she had that notice. If you go past this sign, and I don't necessarily, even though the statute says that, I don't think that there are signs in the parking lot. There aren't signs at the gate. Where the signs are particularly in the Lyon County Jail. The signs are as you pull into the Sally Port and you go into the booking, there's a sign there. There's a sign over the counter at booking that says that they're essentially the same signs. You can't have any illegal drugs, tobacco, or weapons, or you'll be subject to prosecution. And that's, I believe the point that she should have disclosed was when the officer initially asked her, do you have any weapons or drugs?
So when she passed that sign with the syringe and the gun, she committed this crime.
I believe
was
she
Is that
did.
your
I-
answer?
Yeah,
to
I
Justice
thought you
Eagle?
said she didn't pass the sign. I'm
So, no, no,
confused
No,
probably.
she did pass the first sign, but
The sign
she
that
did
said,
not.
past this point, these things are not allowed. 'Cause
Yes,
when I
she-
asked
she
the
did
question, I
pass-
asked her earlier, did the items get past the line? And you said no.
right, and I apologize, Your Honor, the line that I'm talking about specifically is past the booking process. And I think that this case is a little bit different in that the officer did not search her on the outside because of the male-female dynamic and the nature of what he thought the contraband was. He was going to wait and let them search. So I would be willing to give her the benefit of the doubt until she got to that booking and was being searched by the female officers that were making similar inquiries of her at that time. So
But she's penalized because she's a woman?
no.
I mean,
That's
seriously,
that, yeah.
if she had been a man and been searched in the field and they had retrieved the gun at that point, she wouldn't be charged. The way I understand what you're saying.
Judge, I guess potentially that could be the case. She suggested, I believe the record showed that she did not want the males searching her, that she was more comfortable with the females. So I think that was a benefit that they were giving her.
That's not how I read the record. I think that the officer said that he didn't feel comfortable.
And I believe that Mrs. Hinostroza also suggested it at trial that she was, and so there may be both of those, Your Honor, and I apologize if I'm misreading the record.
Does the evidence support the inference, or is there direct evidence that she disclosed the syringe to induce the officers to do a less thorough search for their own safety? They don't want to get poked by the syringe, et cetera, therefore guarding her disclosed firearm.
There's no evidence that I'm aware of that was her intent by the record. I do believe that the officer, when she disclosed the intent, said that he did not want to do it because of the nature of the contraband, and I believe because there was not a female available to help with the search.
What if she had just said nothing this entire time?
If she had just said nothing the entire time, then I believe that she would have then gone into the jail. She would have been searched. They would have found the contraband and she would have been charged the same as she was charged.
Do you?
So the police can handcuff someone, arrest them, physically take them into the jail, and then they're just guilty of trafficking contraband.
If they're on notice that they cannot bring that stuff into the jail
How-
and they don't do something to not bring that specific item into the jail, then I believe so, Your Honor.
I mean, what if they say, well, let me go?
Oh,
That's sufficient?
no, that's not sufficient.
Why? Okay.
Wait, and let me just
you-
understand, what is the practice in Lyon County? If someone is arrested, taken to jail and they have a pack of cigarettes and they're in bookend, that's trafficking contraband?
No, because generally
Why?
that is an otherwise innocent item on the outside. They're usually going to disclose that and they're not.
Well,
going to take it
so,
in.
but if they don't disclose.
If they don't disclose it and they take it in, then that would be bringing
But
contraband.
you
into
say
the
they
jail.
take it in, but they're brought in. Same is true with any kind of item that's found in someone's pockets when they're doing the search. If they don't disclose what they have, that you charge them with a level 5 felony?
No, Your Honor, I believe that there would be some discretion both on the level of law enforcement and the level of prosecution. And I think that that discretion is certainly heightened in a case like this, where I have a situation where there is a gun that she expressly testified was intended to kill herself with.
And
So
so
we depend.
if she were, if she were legally allowed to carry a gun concealed, she still could be charged.
Yes, ma'am.
But if she is legally allowed to carry a pack of cigarettes as contraband, she can't be charged. What's the standard?
I know I'm not suggesting that she can't be charged. I'm suggesting that if she were to take a pack of cigarettes, if tobacco is something that's been identified by the administrator of the jail as contraband and not allowed on the inside, if she does bring that contraband onto the inside, then she can potentially be legally charged.
So we
A
depend,
level 5 felony.
so we depend on the discretion of the benevolent prosecutor, right?
I believe that we always have discretion in how we charge our crimes, Your Honor. This was one of particular levity.
You have several times referred to the intent and that this might have mitigated her intent. Can you tell me what you think the intent is with this crime?
The intent is to go on into the jail while she has that contraband on her person, the dangerous weapon.
And what's the culpable mental state required?
That she knew she was doing it, Your Honor, and she continued to do so.
Knowingly? And you
And
get
she
that,
did-
how do you decide that's the? Because, didn't you charge this as intentional?
Yes, and I believe that it was intentional.
So is that, I'm not sure. So it seemed to me that perhaps the intentional mental state came simply because that was the way you charged it. Can you explain that?
I guess I don't. She had an opportunity to not bring the gun into talking about past booking, which I believe trying to do, and then had an opportunity to not do that, i.e. disclose, was intentionally trying to do it. I don't believe the idea of omission really is appropriate here. To me, an omission would be her failing to bring in something she was obligated to bring in, not saying that she had something that she wasn't supposed to have. It's the act of actually carrying this dangerous weapon and then carrying it into the jail with her after she knows that she. I don't have a question.
Thank you, Mr. Henderson.
Your Honor, I don't have anything in response to my colleagues' comments.
Can I ask you, if the evidence showed that she intentionally disclosed the syringe to, and then the officer's testimony that didn't do a more thorough search because of that, is it reasonable to infer, a jury to infer from that, that she disclosed the syringe to avoid detection of the firearm, and that would get her into the facility?
No, Your Honor, I don't.
Or
I mean,
why isn't that enough for a voluntary act?
yeah, I mean, there's nothing to sort of show that she was sort of kniving at that
notice is
level
a
of
separate
like,
question, I
I
guess.
know that I can just say this, and that's going to get them to not search me for a gun or other things like that. There's no evidence that she had any reason to believe that the officers were going to act like that. That they wouldn't just.
There's
I mean,
two pieces of evidence. The fact she disclosed the syringe, and then there's the officer testimony that says, I did not do that based on that disclosure. And so could a juror infer from that conclusion? Those two pieces of evidence.
No, Your Honor. I mean, I don't think it's a reasonable inference that she was plotting at that level of like, well, if I just tell them about this part, but not the other part, that I won't get searched. I don't think there's any reason why she wouldn't think, why wouldn't I get search incident to arrest? Like almost everybody does for weapons, because that's why we have searches incident to arrest. So I just don't think it's a reasonable inference, Your Honor.
Given your argument, the jury was instructed on intent. Am I right about that?
I was reviewing, I don't have the instructions in front of me as far as what the culpable mental state the jury was instructed on.
Assuming that they were properly instructed on that,
Okay.
have an explanation for the verdict?
Yeah, I mean, given my colleague talks about, well, if you get it past this place or something like that, the jury was never told any of that. And the jury was told if it was brought into jail, you're guilty.
And why? So that's my question. Why would a jury find that this was an intentional act? Given the argument we've had here today.
Because the state was allowed to make the argument as they did today, like that by failing to disclose, that's showing her intent to do this kind of thing, that this was intent. I just don't, I mean, and there are other things in the record. I mean, I don't understand why juries do everything. We can't understand that all the time. But certainly given the way the argument was allowed to be made, because I mean, that's part of why we're here, because we need this court to say that's not a legal argument. It shouldn't be able to argue that. And if, with proper instructions to say that's, it goes back to the question. I mean, because could this have been an instructional? Yeah, there might be an instructional issue in here too. We didn't
What if the gun had been
frame it in that way.
What if the gun had been more effectively concealed? And the other facts are the same, and the gun actually gets into the general population. That evidence.
Yeah, and I mean, I thought about this like a gun. It's hard to, but could there be other things? There could be other things that could be more effective. And if you showed somebody, so you showed more the voluntary act, like, oh, I'm being arrested, and now I show I'm voluntarily doing this thing in order to do this with the idea that I'm going to be able to get this into the general population. Maybe that's not this case at all. There's no evidence like that in this case at all.
The evidence was she had the gun for suicidal purposes, right?
That was her testimony, yes.
And so she doesn't tell the officer because she wants to keep the gun on her in case she can get one last shot in before they take her in.
I don't remember her testifying to that regard, that she,
I'm sure
I mean,
doesn't
she
testify
testified.
to the last. I'm just talking about whether that's a reasonable
Yeah, I
inference.
mean, she
from the
testified,
fact.
she assumed that they were gonna find the gun at the jail. Which is that's a pretty reasonable assumption, I think.
It's also a reasonable assumption to assume that if I partly disclose, I won't be searched by these guys because they're guys. I'll get in and be able to kill myself.
I don't think that's, I don't think that's a reasonable assumption that by doing this, that I'm going to be able to avoid a search for a weapon. I mean, when I read this record, I thought it was remarkable that they didn't search. I mean, that's why we have search incident to arrest, that an officer would put somebody in their police car, not searching them for a weapon. That was remarkable to me. And so I just don't find that to be a reasonable inference.
And was the testimony about the suicidal ideation, wasn't that tied to if she didn't get to see her kids? Wasn't that tied to the family dispute as opposed to
Going to jail? Yeah.
going to jail? Okay.
That's all I have, Your Honor.
Further. All right, thank you. Thank you to both counsel for your arguments today. We will take this matter under advisement.